Member for Mount Waverley.
Thank you, Acting Speaker, and it is my pleasure to stand and speak a little bit on the Justice Legislation Amendment to Criminal Appeals Bill 2019. And I should probably start by acknowledging and showing our great thanks to the Attorney-General and her very dedicated work in not only this bill but also the Serious Offenders Amendment Bill we had earlier in the week, which I also had the pleasure to speak a little bit on. And it shows a commitment from the Andrews Labor government to strengthening our justice system, to better protect our communities. And of course my community of Mount Waverley is the home to the first door to our justice system for many of our justice workers in the academy that is in my area, which is, as we all know, is currently completely full, and we're putting 3,135 police extra into the field. So obviously the justice system we're talking about today is the other end of the process from the police, and also those workers do a great job. But this bill is obviously about the appeals and the removal of de novo appeals from our magistrates' courts to county court system. I should probably also refer quickly to some of the previous my colleagues who have given some very educational offerings, especially the member for Broadmeadows, who was referenced the usage of fear in our politics in regards to justice by some. And I think it's worthy of saying that I think highlighting the fear is not a solution to problems in our society that end up in our justice system. I think it's always better to think of ourselves as part of the solution, and spreading fear is not that. And if you're not part of the solution, then you're part of the problem. So I guess I just sort of put that forward as something we should all remember. Also, member for Oakley, a very good contribution, and the member for Essendon with a little family connection to, I guess, the benefits of a working justice system, which was very interesting to hear. So essentially the bill in front of us has two halves, and the first half, as I said, is to abolish de novo appeals. Now this passed the Assembly previously but lapsed, so here we are again. Let's hope it has a speedy passage through the other part of the House, presuming that we can pass it through this one, and I think we probably will be able to. The other half is introduce a second or subsequent right of appeal, and this is in very narrow circumstances to modernise the way our system deals with miscarriages of justice. So de novo appeals, as others have said, in effect is retrying the whole case all over again. And I think not only is this costly in time and resources of our courts, but also can, as others have said, be very stressful for those victims or people related to the crimes in other ways. And I think this should be reduced. And if I hark back to earlier in the week when we were talking about serious offenders, there was a line of conversation coming from the other side about victims and being supportive of victims in every way we can, which I think the government shares. So removing de novo appeals in this way is continuing that I guess, expression of consciousness that we are aware of the fact that victims will suffer by having to retell their stories again. So I see this as a good step forward, and it's also worth mentioning that we are the last state in the nation to have these de novo appeals. So currently any outcome of a magistrate's court can be appealed to the county court as of right, without needing any particular grounds to do so, which I found surprising when I was researching this bill. and those bills must be heard as new, or de novo. So, under the reforms, these appeals will be replaced by appeals conducted essentially by reviewing transcripts, and admitting only further evidence will be only admitted when it is in the interests of justice and pass that test. And this test of being in the interests of justice will act as a deterrent to sentence appeals lodged by those offenders who are just trying their arm and seeing if maybe it works a little bit better for them. And I think wasting the court's time, the court's resources, the state's resources for someone who's just trying to get one over us doesn't serve anyone, including the person who is probably trying it on, I would argue. So not only are we removing de novo appeals from the magistrate's court, but also we're also reintroducing a reform to abolish the de novo appeals from final orders made by the Family Division of the Children's Court. And these reforms, it should be noted, supported by the Children's Court and DHHS, because they'll spare children months of uncertainty and instability waiting for a full rehearing of the case. I think sometimes when we consider our justice system and we look at the front page of the Herald Sun now and then and we see cases where people raise eyebrows about this or that, and that's fine. I mean, the media is there to shine a light on things that might not make sense or stand out. But I think it's important for us to understand that 99.9% of cases that are tried in our courts go without blinking an eye. That our judiciary, clerks, administration work tirelessly, very long hours, to do the job, their part of our system, just like our police do in their part of our system. And we, of course, are here in the other part. I think it's also worth mentioning that in regard to sentencing decisions, I'm aware that in cases where the average Joe Blow is put into a court for a moot court situation and they try a previous case, and this has been done a number of times by bar associations around the world, etc., but I believe here as well. And in cases where they try those cases pretty well as they have done in court, although the popular media tends to say our judges don't do enough, in nearly all cases where that retrial is done, we end up with the average Joe Blow actually giving a more lenient sentence than the judge did. And I think that would surprise some people, but it's worth considering. There is another part to this bill, and that is in regard to the mercy test. And at the moment there is the channel of being able to go to the Attorney General in very rare cases. This will be changed in order to go to a panel of judges instead. Now, Victoria is the last jurisdiction in Australia to have these de novo appeals, and we must protect our victims when possible and when sensible from having to relive whatever experiences they've been through. We support them in that way. We support them in our policing. We support them in counselling services, and this is the right thing to do. And it's why we're all here, to represent our communities for their safety. And with that in mind, I commend the bill to the House.